Good afternoon, everyone. This is the Patient Notification Task Force meeting of January 21st, 2016. We are beginning this meeting at approximately 3:52 p.m. You may notice task force members accessing their laptops during the meeting. They are using it solely for the purposes of accessing information related to today's meeting. We have a designated time on the agenda for public comment and ask for public comment on each item. I ask that you be respectful of the need to conduct the task force business. Should anyone disrupt the meeting, I will ask that person to conduct themselves accordingly so we may transact our business. This meeting is available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public participating via teleconference, please wait until the monitor has introduced you before you make your comments. To request to make a comment during the comment period, press *1. You will hear a tone indicating you are in the queue for comment. If you change your mind and you do not wish to speak, simply press the # sign. Assistance is available throughout the teleconference meeting. To request a specialist, press *0. During agenda item 2, public comments not on the agenda, the task force has limited public comment period for individuals on the teleconference to 20 minutes. In addition, public comment from individuals here at the meeting will also be limited to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. Business services staff will be assisting me with receiving the public comments via teleconference during this meeting. The task force welcomes public comment on any item on the agenda, and it is the task force intent to ask for public comment. I would like to request all speakers to complete a presenter slip so that I can call you out by name at the appropriate time and that there is a record of this meeting is full and complete. However, this is solely a voluntary request. Please give the speaker's slip to Ms. Lisa Toof. Ms. Toof, can you identify yourself? Hello, to my left. Thank you. I will do my best to call upon everyone who has supplied a slip for the agenda item and to recognize those who wish to make a last-minute comment.
Thank you.
I would like to call this task force meeting to order. Ms. Toof, can you please call the roll?
Absolutely. Ms. Lawson? Here. Dr. Levine?
Here.
Dr. Lewis?
Present.
Mr. Serrano-Sewell?
Present.
Thank you.
We have a full quorum. Thank you very much. On to item agenda 2, public comments on items not on today's agenda. I have no speaker slips. Are there any comments from the phone?
Do we have any comments on the phone?
Right now, no phone questions.
All right, thank you very much. If not, colleagues, let's move to the next agenda item 3. Okay. Agenda item 3, discussion, consideration, and possible action on the mission of the task force. On page PNTF 3-1, you will find the proposed mission of this task force. The mission and objectives were put together based on the discussion at the last board meeting and in my conversations with staff and attempting to summarize the intent of this task force. The objectives contain items the task force can explore in addressing this issue. So, colleagues, if you would take a moment to look at the mission statement, and here's and I want to get input from the task force as well. As you can see from the agenda, we're trying to discuss a lot of important issues beyond the adoption of the task force mission. I don't think at this meeting the task force would be required to take action on every agenda item. We could identify issues, have a discussion about how we wish to proceed, and then take subsequent action. Our normal course is when we have a motion, we have public comment. before the board takes action, a task force takes action. I think in this instance, if everyone is agreeable, we'll sort of take it item by item. Again, my intent is to get public comment on every item. But please know that we may do it after a staff presentation, after the discussion amongst the members, but you will have an opportunity to speak if you want. So for this first one, it's sort of, I'm hoping we can take some action on the mission statement. And we'll go like we normally do. We'll have a discussion amongst the members, make some changes, motion, public comment, then call the roll call vote. So if that's agreeable to everyone, if you have any suggestions, that's fine. Dr. Lewis?
Yeah, I have a comment about the mission and about some of the areas to explore. As you all realize, there's a lot of overlap with the previous committee, and so I'm wondering whether part of our mission should just state really what this task force can do and try not to overlap with what another committee is also already doing. What are your thoughts about?
There will be some overlap, and I think both committees, well, the task force and the committee can inform one another. We don't operate in a vacuum. We'll be giving the full report to to our colleagues at the board, right? So they can have their input as well. So I think for starters, let's just take it on a case-by-case basis, but let's be mindful of that. That it's not the board, it's not this task force desire to, intrude on the work of other committees, but we recognize that there will be some overlap.
Okay.
Dr. Levine?
A couple comments. One, in the mission statement, I think what we want is something a bit broader than just physicians on probation. And I think it might be, as I read through it, it seemed to me that we want to explore methods to address concerns regarding patients, it's hard for me to wordsmith in the moment, but basically disciplinary actions, physicians who have been disciplined by the medical board, rather than narrowly focusing on physicians who are on probation. So physicians, regarding patient awareness of physicians who have been disciplined by the medical board. Now we have, I think, a permanent look back on some physicians, a 10-year on other disciplinary actions. And so it isn't just physicians who are on probation, but we want to increase access to information about disciplinary actions or physicians disciplined by the medical board.
That's great. We've got it up on the big screen now.
And one other thing, I think under objectives, we ought to move up. Part of our objective is to report back to the board with recommendations for consideration for approval or action. That's part of our objective.
We'll move that to the top. Are there any suggestions from the members? I think this accurately summarizes the board's intent with Dr. Levine's suggestions. Dr. Lewis?
Do you think the mission statement, I don't really want to keep wordsmithing it,
No,
but
please. Let's spend a few minutes on it.
it's like the mission of the Patient Unification Task Force is to explore best to address concerns. It's not addressing concerns, it's getting information out there. And when I look at the address concerns, I don't know if that's the focus, just allowing patients to be informed, make an informed choice, and having the physician record is part of that. It's this word, address the concerns regarding, I don't know, somehow that's a little too vague.
I think it captures.
Captures it?
I do.
don't know.
So perhaps what you're looking for is a preamble.
Yes, a
that
preamble.
says the task force was formed in response to concerns raised about the challenges patients have in, A, understanding the mission of the medical board or the work of the medical board and its mission, and B, finding information about physicians who have been disciplined. Then the mission of the task force is to address
Right.
the concerns raised and propose solutions to the board.
Right, that's where I was getting at. But you proposed it very eloquently.
Got it?
Got it.
That's why she's on the committee.
Thank you.
What, can we, I think we can do this, but Kimberly, do you have any thoughts?
I was just clarifying with Dr. Levine's comments. Were your comments to the mission or to the first bullet of the items? Because kind of going back to what Dr. Lewis said, if we change it to methods to address patients' awareness of physicians with disciplinary action, then it doesn't have that concerns in there, and that's kind of at the heart of, I believe, what the mission of the task force is. Would that address everyone's concerns, both Dr. Lewis's and Dr. Levine's?
I think the preamble idea is a very good one.
Right.
Okay.
Yeah,
That's
have
what
that
you're
too.
getting at.
The mission with the as you sort of stated,
Okay.
And then making some changes to the objectives.
I'll volunteer to work with you on wording
Perfect.
that we can.
Thank you.
I was going to volunteer you
And
too.
we'll get to the public comment, absolutely. And what we can do is direct the task force to work with Kimberly in having a revised statement to the full board for their adoption tomorrow. Taking into consideration everybody's thoughts, right, and we have a clear idea of the direction we're going in, I think, right now.
And we can have it tomorrow
And-
available for the members.
Right. Would that work?
Still subject to edits.
It'll work if you have language approved today. Otherwise, you can't continue to work after this task.
No, it wouldn't be. It wouldn't be. It would be to capture what was said in today's task force meeting. But I don't want to get into the weeds of wordsmithing it if we.
So what you're saying, Carrie, is we'd have to wordsmith it. We'd have to come up with language and vote on it here to present it to the board tomorrow.
Right. If what you're trying to say is you're going to present this language that you want the full board to adopt, then it has to occur at this task force meeting.
Okay. All right.
Okay.
That's fine.
Good luck.
If there are no additional comments from the task force, if there's members of the public that wish to comment, I do have some speaker cards, and if they're not on this particular item, let me know. But I have comment cards from Lisa. This was for item 5 and item 6. So, but did you want to talk on the first one, Ms.? Okay. Well, why don't we start to my right, and then we'll have you, Lisa. Thank you. Please. Doesn't matter. Thank you. Good afternoon.
Good afternoon.
Lisa McGifford with Consumers Union Safe Patient Project. And it seemed like this is the right time to talk about what we want to talk about. And to remind you that this task force was created after a petition was filed by our organization to require that all physicians on probation disclose their probationary status to patients. And we would like to see the task force focus be on this population that continues to practice medicine while their licenses are being monitored because of their behavior. And during that discussion of that,
During the discussion of that petition, many of the board members expressed concern that the proposal was too prescriptive and that the proposal failed to consider that some doctors are on probation for minor accusations. So while we don't share those concerns, today we're bringing an alternative approach to you to consider as you work through your do your work and urge the board to adopt it. We recommend that you amend the Manual of Model Disciplinary Orders and Guidelines to require as a standard commission that physicians whose probation is associated with certain serious violations that indicate a threat of potential harm to patients, that they inform their patients of this probationary status. We specifically have a list of doctors that we think should be, this should apply to, and I can provide you that list. But they include gross negligence, sexual misconduct that requires a chaperone when they are seeing female patients, repeated negligent acts, repeated acts of inappropriate prescribing of medicines, controlled substances without medical exams, drug or alcohol abuse, and that's connected with during practice, and also any drug or alcohol abuse that requires regular drug testing, felony convictions, people who have reoffended while on probation, and people who've been placed on probation repeatedly. That's not the full list, but we feel like there are some that are definitely more serious than others, and we're asking you to require, as a standard of probation, that those people advise their patients in a manner that follows your disciplinary order guidelines number 26 with a log. And we also ask that that log include patients to sign that they received the notice. Thank you. I may want to talk on another subject later.
Absolutely.
Thank you.
Thank you for those
I
comments.
have copies of the proposal if you don't.
They were forwarded to us, I believe,
Okay, I
but
thought
you can
so.
at least
Thank you.
appreciate it.
Would this be
Ma'am?
preamble? The medical board, in the interest of patient safety and choosing a physician.
Karen Ehrlich, licensed midwife. Hello. This is a technical comment. My understanding of mission statements is that they must be one sentence long. That they may be long sentences as long as they are understandable. They can have semicolons, but they can only be one sentence long. Goals and objectives are there to flesh out what the mission statement is. I don't know about a preamble. I've never seen a preamble in a mission statement before, and you might choose to ignore me, and that's okay. I just wanted to let you know that that is the general feeling about what mission statements comprise.
Thank you. We're going to have, are there any other comments from the public? Well, those comments were helpful. And what in speaking with counsel, I'm thinking of a motion that would assign Dr. Levine to work with our executive director in making refinements to this mission, to this statement, for presentation and adoption at tomorrow's full board meeting, taking into account the tenor of the discussion this afternoon.
Right.
Preamble, the objectives changes, but I think we have a sense of what that looks like if it were to deviate. It's not further policy discussions between yourself and Kimberly. It is merely sort of to execute the discussion we're having today.
So can I I'll make that motion as stated?
Do public comment again.
Okay, I'll make that motion now.
Yes, please.
Make the motion as stated.
All right. Is there a second? Second. Thank you. There's a second. And being our practice, now that there's a formal motion on the table, if there's any public comment from the public present, now's your opportunity. Thank you. Seeing no public comment, is there any public comment from the phone?
Do we have a comment on the line?
Right now,
All right.
no
Thank you
questions from the phones.
Thank you very much. Ms. Toof, please call the roll.
Ms. Lawson? Aye. Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Mr. Serrano Sewell?
Aye. Thank you very much. This was a good process, and I know I appreciate, and the full board will as well, and this task force. On to the next one, discussion on outreach to the public regarding physicians on probation. Ms. Kirkmeyer?
Thank you, members. We have a presentation here that we want to walk through because before you have any discussion on this, we actually wanted to walk through what currently is done when a physician is placed on probation. And really, in regards to Dr. Levine's answer, this actually would be for any physician that gets on disciplinary action. So it would be all the way from a public reprimand all the way to revocation, I believe, for all of these that we're going to be going through. So we thought it would be important to lay down kind of like the ground level work as to what the website has, what we do when an individual has disciplinary action. So then that will further your discussion when you hear public comments and kind of go from there. So the first thing that happens is we actually update the board's website, and that's that physician profile. For those of you that attended the earlier committee meeting, it would be this document here, and as you can see, we've actually made this a non-specific. It's Jane Doe. This really is not anybody. So Jane Doe here, you can see there on the secondary status, we changed that to probation. So before the action took place, it would have just said renewed and current, no other information on there. And so we add that probationary status, and then down at the bottom, that administrative disciplinary action turns into one found, or it could be more found if they had other action. But then that changes to found, and then what happens is, thank you, Dr. Lewis. So you see down here, this is where it would change here to indicate the action. And then once the person clicks on that, it takes us over to this document. This is kind of like what we call our public disclosure web page, and it will give the name. And then in here, it talks about the terms and conditions of that probationary order. So the public can actually see everything that has been attributed to that doctor and what they have to do. I think the next page actually has just this is just basically, you'd have to scroll down on that, and we don't have that scroll because we had to put in Jane Doe. So, but if you looked at it, this would be the information that's there in that website. So that's the first thing that we do. And when I'm talking about what we do, we have a lot of things in the backfield that we do, but this is something that's available to the public. So all these actions now are things that are available to the public. Oh, right. And then we have the URL link right down here that actually then takes you to the entire record of that physician's action. So in this particular case, if this individual had just been placed on probation, it would take you to the stipulated decision and the accusation in this matter. If it's a proposed decision, it would just take you to the proposed decision on that matter. So that's the first thing we do. Then the second thing we do is we have a board subscribers list, and we issue a license alert. So on our homepage over on the right-hand side is a button that says subscribers list. You click on that and it takes you to this web page here. This allows an individual, anyone, to go ahead and sign up for what they want to see. So we have, I don't know, Shar, do you have any statistics on subscribers?
Not
okay.
About 2,000 that apply for just the subscriber for the alert.
Okay, so any individual, no matter who you are, can go out and you can click whatever you want to see from the medical board. We use this for our board meetings and regulations, but you can also sign up to get the activities of any disciplinary action, any action related to the doctor's practice, and then you put in your email address, and what happens, it's okay, go ahead. And then what happens is this email comes to the individual. So I'm John Public. I go subscribe, and when these individuals had action taken against them, this email comes to me, so I can find out about a physician. I know some of the issues have been, well, I checked my doctor once, but then I may never know again. Well, if you subscribe to our subscribers alert, our license alert, you would actually know if your physician went on probation later on. Now, you would have to obviously look each time you got this email, but at least it would provide you with information about individuals who have been placed on probation on that day or during that week. Okay. So the next item is actually a pending item, but I wanted to bring it up because I think it is tremendously helpful, and it will be. It's a Breeze subscription. So back on that license screen where I showed you when that license status had probation on it, we believe, and we're talking right now with the Department of Consumer Affairs, so this is pending and it's something we're investigating right now. But we're looking in, there is a possible ability that when you go into Breeze, you can actually sign up. So individuals that go in can actually make an account with Breeze. Then they would be able to subscribe to a licensee. And when that licensee's status changes, it will actually notify them. So this is something we're looking into. We're working with the department, but if this is something that's going to be available, this is a great impact, and I think something that you need to know that that's a possibility that's out there that we're looking into.
If they go delinquent, canceled, any status change should be covered.
Right. And there is a difference between the primary status and the secondary status. We're looking into if it's only the one primary status or if it will also include the secondary. If it doesn't include the secondary, what our IT shop has planned is to put in a work authorization to the department to also include that secondary status, because we think this would be very helpful for the public.
What's the difference between primary and secondary status?
So, how do I describe this? So the primary status is really, can you practice? You'd have revoked, renewed current in there, delinquent. Let's see, I'm trying to think of all. It's the main license status. All of the others are added onto that. So you also have a public letter of reprimand. You also have probation, but your main primary status is still that you're renewed and current because you can practice. Does that explain it? It's kind of like additional information on the person's license.
The primary status more controls your renewal ability and the life cycle of your license, whereas secondary status are information like you.
Okay.
That you can see on the profile. The primary status we refer to is the license status labeled there, and then you can have 0 or many secondary statuses listed after that.
So it's can you practice or not? The secondary is, are there conditions connected to your practice?
Right. That would probably be the best way to describe it. Okay. Then the next item is the newsletter. So each quarter, when our newsletter comes out, we actually provide information on the newsletter for the individuals who have had any disciplinary action taken against them in the last quarter. So here, we copied this right from our newsletter. So this is right there. We say where they're located, the action that was taken, and the date. And then in addition, recently we also added the link. So if you're looking at this online, which 3 of our newsletters are online, you would actually go right there, click to that, and that will take you to the document that describes the action taken against that licensee.
And we can have them subscribe to this as well.
That's right. And you can also subscribe to the newsletter. So each time the newsletter comes out, that you can go through and look at those. Okay. So then the next thing that we do, and this isn't really pertinent to patient notification, but we think it's important that you also are aware, we also send the information of that action to the National Practitioners Data Bank, and those who have the ability to have access to that can get that information. And then the next thing we do is we send it to the Federation of State Medical Boards, because they actually have an alert that notifies any state where that physician will hold another license. It notifies that secondary state, so then they can take action if they feel it's warranted in that state. And then the last thing, we really just want to again point out, because we know that there's an issue with individuals not having access to a computer, and we completely understand that argument and that issue. And we do want to make sure that everybody knows that our phone number is here. We have the 800 number that an individual can call. And I put on here available anytime. That's actually not true. It's available Monday to Friday, 8 to 5. So anybody can call during that time. They can either hold for an attendant or they can ask for a call back. So those are the ways that individuals can get notification. So from there, I'm going to kick it kind of over to the task force to discuss those and see if there's any other changes that they would like to recommend.
Dr. Levine?
So this is very helpful, and it suggests to me there may be an opportunity for the physician, the patient, the Public Outreach, Education, and Wellness Committee to follow the first wave of checkup on your doctor's license with a subscribe campaign. Once you've been able to confirm, because I think the primary license status alone doesn't give a whole lot of information, but if in fact we get to the point where a BRE subscription could actually identify primary and secondary, we could have a simple campaign of, how to subscribe, how to get information on an ongoing basis about physicians you are seeing or you may be interested in seeing, something like that.
And that's actually something that Ms. Hawkinson really is targeting now when she gets calls from individuals in the press or anything. Hey, you can go out and subscribe to this. And she's really been talking when she gets callers as well to the media, because then that also alerts them. So this is something that we completely agree with, yeah.
Are there any additional comments from the task force members? No? Any comments from the public?
Right now, no questions from the telephones.
Oh, thank you. Julie?
Thank you. Julie D'Angelo, Falmouth. Is this on?
Yes, it is.
Thank you. I think what confuses people, Joe, normal consumer people, is when they go on the website, or on Breeze, and you look under, what does it say, primary license status, and it says renewed and current. I've seen doctors whose record underneath renewed and current says probation, suspended, cease practice, other stuff under there, but you don't get there because it says renewed and current. And I guess what I'm suggesting we think about is maybe you put probation, in that case right there, in red. Some other boards do that. If there is disciplinary action, it's highlighted in some different color to give you a sense of, oh, okay, there's a flag here, I need to check this out, and then I can make the decision whether I want to go there or not. But the way this is set up, and maybe it's necessary, license renewed and current often doesn't lead me to go any place, to look beyond that, below that. And that causes confusion.
Thank you. Are there additional comments from the public? Seeing none, are there any comments from the phone? This is on item 4.
Any comments?
No question currently.
Okay, I don't see a motion here for this one. No, this was a report. Thank you very much. Again, we've taken a lot of notes, and that'll be included in a report to the board that the task force will publish after today's meeting, after tomorrow's meeting. It'll happen soon, but not in the next 48 hours. Anyways, on to item 5, discussion on information available on the website regarding physician discipline.
So the same kind of concept. Again, we just wanted to walk through the website and let the members know what's available on the website as well. So, and the couple of these are going to be really short because we've already talked about them. But obviously on any physician's profile, once they go on probation, that information's there, the document's available to the public. So the next thing is the newsletter. Again, we also, and the reason I put it in both places is because to let everybody know it doesn't only go out when it first happens, but then those newsletters are held on our webpage. So if an individual wanted to go back to, 2 years ago and see what disciplinary action was taken in that quarter, they can go out and look at it. But the third thing, and I know this has been brought up a lot, but the enforcement public document lookup is a invaluable tool to me. I almost use this on a daily basis. And what you do is once you get in from that home page into the search, you can actually type in the physician's name. So in this instance, not to put anybody under the gun, we just put AM in. So we pulled up the whole list of documents for the individual with AM. And especially with the passage of AB 1886 that happened last year, now all documents that were an individual's on probation, those will always remain on their record. In the past, it was only there for 10 years, but now it's there forever. So once you go there, you can actually look at that list, click on the link there that will provide you once you scroll over it with the highlight, and then it will go to the actual document for that physician. So we think that this is a helpful tool for the public because you don't have to look at anything else. If you're just really looking, do they have any enforcement documents out there for them? Here is the information. And the reason we say, which we do need definitely to clean up that sentence, but the reason we say that is because we also want to encourage everybody, also look at the physician's profile, because there might be information there that you won't see here, such as action on a felony conviction could be there while the case is ongoing, but at least you'd know the felony conviction, there was something there. So we also want to drive them to the patient or the physician profile. And then the last thing, and this goes actually to a comment that was made earlier today, and I don't think a lot of people maybe know this is out there, obviously, and so we also have a disciplinary action license alert page. And so if you go from our web page, so if you go to publications and down, if you look at disciplinary action / license alerts, you can click on that. And I'm not going to walk through there, but there's the years, and then you can flip over to the other one, Sean. What happens is once you click on that document, This pulls up a list of all of the actions that have happened in that year. And for like, if we pulled up, we only have 2015 on here. So an individual could go out there and look. Here's the name of all of the actions that have been taken in the last year. So if they wanted to go there, it comes up in Excel. So if you wanted to search your doctor's name, now it's only for that year, and that's only the actions that happened in that year. You can actually search and find out any physicians that had in that time frame. It does have the city. So that was something that an individual brought up. I'd like to see all of the individuals. Again, it's only for that year, but they can definitely do a search by city and pull up the information of all the doctors in that year that had action in that certain location. So this is something that's also out on our webpage. Anything I'm missing on that? No. This actually, just to give you a little bit of history, we used to actually do a hot sheet that we would provide to individuals, and this was a follow-through now when we started doing the alerts that we actually put it on this hot list. So those are all of the information that is available on our website to indicate an individual has had disciplinary action.
Dr. Lewis?
Yes. Question. The pending cases that are pending from the AG or whatever, you can look that up internally, right? You can't look that up public, and I assume it's because if the case isn't closed, it could be expunged, or it could have a better outcome, or...
Actually, that's a great question, and I'm glad you asked that question, because there's more to this story than meets the eye about what we post on our website. So the medical board is probably one of the largest statute-driven individuals of what we can post on our website. We have two sections of law, 803.1 and Business and Professions Code 2027. Both of those sections of law drive everything we can maintain on our website. Just like earlier, the paragraph that was discussed, we'd like to have a paragraph on the physician's profile. Any type of change like that outside of what we already post on a physician's profile would have to go through a legislative change. So for example, one thing we do say, and can you go back to our lookup and get to what is and is not? One thing that we do, Dr. Lewis, though, we do want to let individuals know what they can and can't find on our webpage. So if you go to our one page, so right here it talks about under California law, the following information is confidential and not public and would not appear. So you see complaints, investigations, and then the misdemeanor convictions and some medical malpractice information. So we want individuals to know you can't use our website to say that there isn't anything pending, because these things might be available, but by law we can't post any of that information until an accusation is filed or an interim suspension order.
Okay, because there was a comment earlier about just put everything out there, even if it's pending, but what if the pending case gets thrown out and there's no action, then you've labeled this,
Yeah, and
we
that's
don't put any of
exactly,
that, so,
and
right.
again, it goes to what the law says.
What the law says, that's, thanks.
For those reasons.
Yeah, that's what I wanted you to clarify, thank you.
Perfect.
Thank you, Dr.
And then
Staff.
there's one more document. It's a long and convoluted document, I have to say, but we want to make available everything so an individual will know when the information is available, because we do have, because of our law, we have one law that says what is public, and some items hold to a government code section even, and then we also have the law under 2027 that says what we can post on our website. So we provide this document out there to let individuals know. So for example, a court-ordered restriction, it's only available while that person is basically under that court order restriction. However, it's always public at the medical board. So if you made a call to the medical board or you walked in, that information would be provided to you if you made like a Public Records Act request. Just like a public letter of reprimand now, it's only there for 10 years. Although it's only there for 10 years, the document is indefinite, but it's just that it can't be posted on our website for more than 10 years.
So I just want to understand what you can and can't change. So that paragraph on disclaimer, you're saying that's...
No, we can change it. I'm talking about on an actual physician's profile.
Oh, okay.
Any addition to information there would have to go through a statute change.
Sure.
Yeah.
So as you're going through all this, after 7 years on the board, I got lost. And so I wonder whether we ought to think about something for the website that in the format either of a Q&A or a narrative that explains in eighth grade literacy level, if you want to learn this, here's how to find that information. If you want to learn why, either a Q&A, how do I find out, how do I learn whether my doctor's license has been disciplined, or or some way for the average person who is not a regulator, it isn't even a licensee, or not a regulator, to be able to navigate what is obviously a wealth of information, but not terribly accessible. And, the other thing that strikes me is that none of us in this room are average consumers. And so giving people information that is useful to them, there's a point in time when there's a desire and a need for information, and when you inundate people with information when it's not high on their priority list, it doesn't stick, they can't use it, and it's just an annoyance. And so figuring out how to respond to an interest, a need, and to some extent stimulate interest without assuming that the 30 million people in California think about us every day, even think about their doctors every day. And so making the information as easy as possible to access without assuming that everybody wants all of it all the time. And I mean, I think that's all of our challenge in our day jobs, actually.
Definitely a task for Ron's committee.
Yeah.
That's a
And actually,
serious
I
issue.
think the tutorials, if we,
Like the fact sheet idea.
a fact sheet and a tutorial, if we can actually do video, even a short snippet video, that's where we really want to go, because I think those are easier to watch rather than reading this big prose document. And so maybe we can actually think of some other ways, like if you want this, and then you can just have a talking head even, or, some examples of how to get into the website, some tutorials. That might be something we can look at as well. It's just outlining it to where it grabs their interest to want to click on that and understand it.
It's so helpful if we had the ability to do focus groups of different groups of consumers to understand what are their highest priority interests and needs, and when would they want that information.
Okay. I do have a speaker's card for this item. Ms. Ramos?
Good afternoon, board members. I'm here on behalf of Consumers Union Safe Patient Project, and we're pleased that you're taking steps to ensure the website is useful and effective for consumers who want to know more about their doctor and understand their doctor's disciplinary history. As mentioned earlier today, we believe that most patients who actually find their way to the appropriate website page will have great trouble digesting the current content. When the patient finally reaches their physician's profile, if the doctor has been disciplined, a brief summary of the reasons for the discipline, the timeline for probation, and any practice restriction should be readily visible to the patient and written in plain, easy to understand language. The brief summary should be located under the physician's name and license number. The patient consumer should not need to scroll through optional reporting information at the very end of the profile to find a link to a public document, as most consumers will not scroll that far. Now, in mentioning what Kim was just talking about, it's really interesting. I spent a lot of time on your website. I've never seen that document. Now, I mentioned this earlier with public documents. It's shown twice in your revamped website, and a lot of consumers aren't going to know that that's going to lead to disciplinary actions. So if you could, in parentheses somewhere in really plain language on both links listed, has your doctor been disciplined, disciplinary actions, etc., and so consumers will know that that public document is going to lead to disciplinary actions if there are any. If we want patients, consumers to be informed, you need to give them access to your information. And that was an interesting document I just saw, but I still think it would be easier within the physician profile if you added an additional search entry, which would be a physician, in the physician profile search. We're asking that the search be changed to include a multiple search entry, and that a physician discipline search entry be included on the physician profile. With the additional search entry and the multiple search capacity, a patient in the physician profile can search for all doctors in, like, let's say, Pasadena, who have disciplinary records. So you could find out firsthand which doctors in Pasadena have public reprimands or are on probation. The multiple search entry would help patients find doctors by discipline in their city. So you could add a specialty entry to the search so patients can search for all cardiologists in Long Beach. I know, and you're making great strides, I appreciate it, but I know we can give consumers more information on their doctors, on the internet, and in person to fulfill your mission, commitment to California consumers. Thank you.
Thank you for your comments. Other additional comments from the public? From the members present? Public present? None? Thank you. Any comments from the phone?
No phone questions.
All right, thank you very much. Again, this was a discussion item, no action taken. On to item 6, signage required pursuant to Business and Professions Code, Section 138. Ms. Kirkmeyer?
At the last board meeting, a number of comments from both the board members and the public were received regarding the signage that is required in either a physician's office or in certain documents provided to the patient. The comments centered around the language on the notice and the fact that more information wasn't provided, such as informing the public to check on the physician's license status or that a patient should file a complaint about the physician with the medical board. The intention was that it would cause the patient to go to the board's website and check the physician's status to see if he or she was on probation. The regulations requiring the signage was required based upon Business and Professions Code Section 138, which states that in part the board must adopt regulations to require its licentiates to provide notice to their patients that the physician is licensed in the state. And I believe in your board packet, and it's up here too, is that section of law. This statute is the authorization for the board's regulations. Although at first it would appear that this legislation may be broad, and the board could amend the signage to include more information, upon a further review of the legislative history, our legal counsels have determined that the language is actually very narrow. I will ask Ms. Webb and Ms. Dobbs to speak on this, but this information will limit what the board can propose in a change to this sign, and I wanted the members to be aware of this prior to initiating this discussion. However, the board may look at amendments to the sign, and rather than go through the regulatory process, either bring this issue up in the board's next sunset report or seek broader legislation. Those are your options that you have before you, and I'll ask Ms. Webb and Ms. Dobbs for their opinion based on their legal analysis.
Well, like many of us, we were hopeful that we would be able to add some additional information required to be on the sign through regulation. But in looking at the legislative history of Business and Professions Code Section 138, in earlier drafts, the language actually was going to say that the licensee had to indicate whether his or her license was in good standing, and the means for contacting the board for the purpose of seeking information or filing a complaint. That language in the earlier drafts of the legislation was specifically stricken out, and that left a very bland authorization to boards for requiring what licensees have to put in their signs. So because this was in the earlier drafts and specifically stricken, it's our belief that a legislative change would be required, and we couldn't do it just through regulation. We don't have the authority to do it.
And again, that statute really just says that you can say that they're licensed in this state, so.
Dr. Levine?
Does that section of law apply only to medical board licensees?
No, this is boards throughout DCA.
So presumably any change to the legislation would apply to DCA boards, all DCA boards?
Yeah. And unless we made it specific to the Medical Board of California and put in our own section that said that we could do a sign that says whatever you want to propose.
Well, this signage question intrigues me because it is, by state law, an area that this board and the other bureaus and boards under DCA have some say on the real estate, what it potentially could say. And, you know, you see the bumper stickers on cars, how am I driving? Call this number. And having some additional language to that notice is an idea I think this task force should explore, and balancing all the interests. So perhaps at our next task force meeting we could have a more in-depth discussion about that. We've had suggestions from the public about what it could look like. And I like your idea, Kimberly, if this goes anywhere, to include in our sunset report to the legislative body, should they decide in their own discretion to have this board continue, that it include the appropriate amendments in that reauthorization legislation. And they're the ones that drafted this one, so they'll have the legislative history as well. That might be the way to go. Are there any additional comments from the task force members? Any comments from the public? Seeing none, are there any comments from the phone? Oh, I'm sorry. Oh, ma'am, I apologize.
No comments or questions.
Ms. Hollingworth? We're going to take a public comment on item 6 from Marion Hollingsworth. I apologize.
My name is Marion Hollingsworth with the Consumers Union Safe Patient Project. Regarding the signs, I went over previously what we had suggested to add information about on the signs about using the signs as a way to tell consumers how to look up their doctors and also how to file a complaint that they can go to the medical board. I'd like to ask the task force and the medical board to sponsor legislation to allow the medical board to make changes to the signs so that consumers will be told they can contact the medical board for complaints or for how to look up their doctor to find out his or her disciplinary history. And on my own, as a consumer, I'd just like to say that the task force was formed after Consumers Union filed an administrative petition to require doctors on probation to inform their patients. Everything that has been talked about today so far has been putting the burden of finding out this information about doctors on the patients. No one on the board has said anything about putting responsibility on the doctors, the ones who got in trouble in the first place for not meeting standard of care. If you are concerned about the cost, the easiest way is to come up with a form that both the doctor and the patient have to sign acknowledging that the patient was informed that the doctor was indeed disciplined and on probation. If you are spending countless hours and dollars thinking up ways to inform the public, why not just take the easiest and most direct way to require the doctors themselves to tell the patients? I think the task force should consider this in addition to showing patients how to look up their doctors. Thank you.
Thank you for those comments. Are there any additional comments from the public on this item? Are there any comments from the phone?
No phone questions.
All right, then, thank you very much. We'll then move on to the next item. Ms. Kirkmeyer?
Okay. Well, although the board denied the Consumers Union petition at the last meeting, which was to amend the board's disciplinary guidelines, the members had discussed looking at alternative proposals to address this issue in the disciplinary guidelines. Prior to the members' discussion, I wanted to specifically indicate which conditions have some type of notification, so I'll be going through those. In addition, at the last meeting, I stated that there was only one board that currently had patient notification in its disciplinary guidelines, and that this board had not used the optional condition to date, and that was the Board of Optometry. I wanted to notify the members that at an enforcement committee meeting of the Board of Chiropractic Examiners a few weeks ago, that committee approved a proposal to add patient notification to their disciplinary guidelines. Now, this recommendation has not been adopted by their full board, but I did want to let the members know that it was a proposal that they were discussing. So going to your handouts, your document, if you look at the disciplinary guidelines and on page 21 of the document, these two are back to back. We actually have the third-party notification, and currently it's condition 25 of the board's disciplinary guidelines pertaining to a third-party chaperone has optional language that can be added to a decision requiring a physician to provide a written notification to his or her patients that he or she is required to have a chaperone. And then right below that, in addition, condition 26 regarding prohibited practices requires the physician to notify all patients being treated that he or she is prohibited from performing that procedure. And any new patients must be provided the notification at the time of their initial appointment. Now, both of these conditions require the physician to notify the patient of that specific condition, but they actually don't require the physician to tell the patient why they have this condition imposed. So the task force could consider making changes to the disciplinary guidelines, but again, any changes would need to go through the regulatory process. And I leave it up to discussion.
Dr. Levine?
Just a point of information, how many physicians on average in a given year are on probation?
So I think earlier today, Ms. Delp said right now we have 614, I think, so about 600, anywhere between 500 and 600 in a given year are on probation. And I believe it was either last year or the year before, I think we put about 122 individuals in that year on probation.
Are there additional comments or observations? Dr. Lewis?
And how many, to go along with Dr. Levine's comment, how many follow or, how many are in the categories of those two disciplinary guidelines, would you think?
Oh, I'm glad you added that, because I wouldn't be able to answer that without going back and analyzing it. But I would think that it was a very low percentage.
Low.
Probably, because it's a sexual misconduct case, which isn't one of our higher categories. And then the prohibited practice, that's, not that it's rare, but it's, maybe like 5 to 10% of the individuals that actually end up where they can't actually practice a specific function.
Procedure,
thank you.
Okay, so those are the only two categories where there's a disclosure
Right.
required by law to the patient.
To the patient. There's our notification to, other entities and their employers and everything,
those are,
but that's,
right, and those are very low numbers
I would think.
in your estimate.
Yeah, if you're asking me to kind of get a wild guess, I would think that these two are probably low.
Thank you.
Christine?
On the prohibited practice section here, it looks like the requirement currently is just that all patients being treated shall be notified that the respondent is prohibited from practicing, performing, or treating X. Can the physician or the physician's office provide any sort of notification they want? Does the medical board or staff review the notification they provide? Because you presumably could, sweeten that up to look like we're just simply not performing this anymore, rather than we've been disciplined and are therefore not.
Unfortunately, our probation monitor expert is out of the room, but I believe they do look to ensure that they've provided it, but I don't know if they check the wording of it. But I believe that they do, but I'll have to get back to you on that to give you exactly what they do, what they require the physician to notify them of. If it's just a sign that says I can't do these, and then when that patient, obviously, if the patient were to ask the physician, we don't have any authority over what we can say, of what he can say, except for he has to tell them he can't perform it.
Mm-hmm.
What he says, the reason of why, we don't have that requirement in there.
I guess the difference is it's one thing to say, I'm not performing, these sorts of procedures anymore, and it's another thing to say I'm prohibited from performing them.
And correct me if I'm wrong, many of these cases have, in addition, a part of their probation, a practice monitor. See, the practice monitor gives a report back to the board, so we don't know if that's part of their checklist.
Usually it isn't. This condition is separate than the practice monitor. I don't think the practice monitor looks at this. I do know that, and Ms. Delp can back this up, I do know that our monitors check this and check to make sure that they are providing this notification and that it is in their log that they've provided that notification. I just don't know what the notification looks like.
Okay.
But yeah.
Thank you. Are there any additional comments from the task force? Seeing none, I'll ask if there are any comments from the public present. Yes. If you could identify yourself, thank you.
Sarah Huckle with the Senate Business and Professions Committee. I just wanted to get clarification that even if the disciplinary guidelines were to be updated, there's no guarantee that every physician on probation under the categories would necessarily disclose as a term of their settlement, right? Okay.
I'm sorry, sir. Can you
So even if the disciplinary guidelines are updated, there's no guarantee that every physician on probation would adhere to those terms because it's dependent on what the ultimate resolution is with the AG and everything.
Right. Sorry. If they were amended and it was an optional condition, it would be up to the settlement negotiation to put that into that certain item. Even if it is a standard condition, as you all know, because you see this from time to time, there is always that negotiation during the settlement conferences and settlement on that case.
Okay, thank you. Great question. Are there any additional comments from the public? Yes, please.
Okay, I'm going to be a broken record because I just want to say again and make it clear that we're trying to get the board to create a standard condition that for certain people on probation for certain reasons, serious reasons, have to tell their patients that they're on probation. And I know that we've been told that often is negotiated away, but if you look at the probation orders, you will see that almost all of them have the standard condition that they cannot supervise physicians' assistants. Now, why would that take precedence over telling a female patient that they're on probation because of sexual misconduct, and so they have to have a chaperone in the room with the patient? Why would that take precedent? And that is on almost every single order. I think it might be on every order. That is a standard condition, and it's there. And that is not negotiated away. So what we want is something that isn't negotiated away, and I understand how these things work, but it's it's pretty important to have this as a standard and not as an option. If it's an option, it won't be used. And that's what we're asking you to do, is make it a standard under certain circumstances. That patients be notified about their doctor's probationary status. Thank you.
Thank you. Are there additional comments from the public? Seeing none, are there any comments from the phone?
We do have one question from Robert Stewart. Robert, your line is open. One moment.
Robert Stewart.
Robert.
Pardon me? Oh, my name is Robert Stewart. I am private counsel for healthcare professionals all over the United States, particularly physicians and dentists I've been at it for 30 years. And I want to point out that, and probably what you all know, but still, the current procedure for notifying the public of the probationary status of a physician is to list all such matters of current probation or past probation, accusations against the license, settlements of the accusations, conditions of probation, the nature of the misbehavior, and the findings from a trial of an accusation. But every so often in public life, some well-meaning person or organization decides that there are people out there, the public, which need to be protected from some perceived evil. What this often means is to insist that the public be protected even when it has no desire to be. This proposal by Consumers Union is essentially to force the public to be interested because Consumers Union believes that it should be. As it is, any patient has the right and the means to get on the internet a full history of their physician. To compel the physician to notify each patient of the probation believes that it will confuse the patient. It will be read as a suggestion by the physician to their patient of their incompetence to handle the care of the patient. It will provide the patient with far more information, and it's always stated in legalese, which is very difficult even for me to understand, and that patient will never understand it. It is also true that when the medical board places a physician on probation, it has decided after very careful consideration that the physician can safely practice within the framework of certain terms and conditions. Notice from a physician to a patient of the existence of that invites the patient to try to understand what it all means. Does this mean I shouldn't trust my doctor? Is the medical board trying to tell me that my doctor is dangerous? I can tell you of a case I handled of a dentist in Wyoming, and the proposal for settling the case, the doc was a drug addict, street drugs primarily, excuse me, and he was in recovery at the time, and the board there wanted him to put a copy of his probationary order in his waiting room, and wanted him, when he seated a patient in the chair, to give that patient a notice that the patient had to sign that he had read this notice saying, this dentist is on probation and you may want to go somewhere else to get a different opinion or another opinion on whether you need this work or not. This kind of warning and this proof that the patient has read it, signed, and so on is way out of line for any real danger to the patients. The patients know who their physicians are and their dentists, and they can look that up online. So I'm saying that there isn't a need for this change. So thank you for the opportunity to speak to it.
Thank you. Are there any additional comments from the phone?
No additional questions or comments.
All right. Well, I will now move to item 8, future steps. And let me provide you with my initial thoughts. One is we'll have a revised mission statement at tomorrow's meeting that we can present for adoption by the board. In terms of next steps, meetings-wise, I think at least one more meeting is called for now that we've had a good discussion and some information, and there's some Dr. Lewis's committee touches on a lot of this as well. What I'd like to do is get your comments, put together a memo with Kimberly's input on what the sort of next steps could look like, and have that properly agendized at the next our next full board meeting in April, I believe. Is that in April? May. Our next full board meeting in May. So we'll do something like we did for this board meeting. The task force would convene at that time. Those are my initial thoughts, and this report would summarize the comments that were made today and some of my thoughts and recommendations on how we might proceed. Is that agreeable to the task force?
Yes.
Thank you. Do we need a motion for that? No, that's fine. I think that's okay.
Yeah, you can direct staff to work with you.
All right.
on
I'll do that.
Summary.
Oh, all right. Staff will do that. Thank you. Are there comments from the public on this future steps item and how I've just sort of articulated it? Seeing none from those present, are there any comments from the phone?
No questions or comments from the phones.
All right. Thank you very much. Now we'll entertain a motion to adjourn.
I move to adjourn.
Moved, seconded.
Second.
All those in favor say aye.
Aye.
Aye, motion carries. Thank you very much. Thank you, staff, and to the public.